Today I'm going to discuss the scenario when you have inventors who are not in the United States. So in patent law internationally, each nation has its own patent office, with the European Union having its patent office that includes several nations. And typically, when an inventor invents something in a particular jurisdiction, there's some hoops you need to jump through before you can file in another jurisdiction. And this is typically comes up quite often. I have clients who have their main office here in the United States, but they'll have a research in India or somewhere else. And when the inventors are in India and the invention occurs in India, then we need to look at some of the things we're going to discuss today. If it doesn't, what controls is not where the company is incorporated or the citizenship of the inventor. What controls is the location of the invention. So, for example, I'm a United States citizen. If I'm visiting India for only a layover of 2 hours and I invent something while I'm on that layover, technically I would need to do one of these options in order to return when I return to the U.S. to file in the United States. Now, practically that may not be an issue, but at least from a hyper-technical legal perspective, that's what would need to be done. So let's take the example of you have inventors in India, and the goal is to file IP in the United States. Okay, so there's several options. The first option is to draft the patent application here in the United States, and then obtain a foreign filing license in the country of invention, then file in the United States. So we would file, like for example, if we were going to file a provisional patent application for inventors that were in India when the invention was invented, we would draft the provisional patent application or utility application here in the United States. We would submit it to the Indian Patent Office, and then in a few weeks we would receive a foreign filing license. We'd use an Indian patent attorney to do that. And then once you have the foreign filing license, that means the Indian government had reviewed the invention, determined it isn't a threat to national security or whatever, and is given permission to file in the US. It's the same thing. If I file in the United States and I want to file abroad, for example in India, I would take the application, give it to the US Patent Office, and receive a foreign filing license after they review it to file in another jurisdiction, for example, India. I know in the United States, if you do file, for example, if you filed a provisional patent application in the United States or a utility application, the foreign filing licenses are usually automatically generated shortly after that filing. But you can request a foreign filing license in a separate action with either patent office. So that's the first option. Draft the application, go to the country of invention, get the foreign filing license, and then file in the jurisdiction you want to file in. The other option, which is pretty common as well, is you draft the patent application, but then you file it in the country of where it was invented, and then in 1 year under the Paris Convention, you then file in the target country. And a good example of this is we draft the provisional patent application. It's Indian inventors in India. We file the provisional patent application in India or a utility, whichever one. And then we have 1 year to file that application in the United States. So say, for example, today's date is 11/29/2017. Would say you filed the provisional patent application in India today. So in the United States, under the Paris Convention, you would have until 11/29/2018 to file the utility application in the United States, and you claim priority under the Paris Convention to the Indian application. That's it's a little bit simpler, and it's one of the reasons I like the Paris Convention, because of its simplicity and straightforwardness. The Paris Convention is usually really good to use for startups. It's because it's simpler, there's less chance for mistakes. The costs are a little bit lower than the other options. And usually startups, you're only interested in typically in filing in places where you actually have a market or potential market. So that's only going to be 1 or 2 jurisdictions at most. So for example, if you're an Indian company, then India would be a country you want to file in, and the United States is typically a country that investors want you to file the patent application in. So I spent quite a bit of time actually talking clients out of the third option, which is the PCT, the treaty, because of cost and procedural complexity. And I'll make another video probably in the future about the PCT process. So I'll skip that now for simplicity and just to be efficient with time. And finally, there's a fourth option. It really depends on the country of invention. It's not really something I would recommend as an attorney, but I have seen people do this where they skip obtaining the foreign filing license. They don't file in India and receive and then proceed under the Paris Convention. They just take the invention and file in the United States. There's potential problems. For example, in the United States, if you invent something here and file abroad, if you get caught, the USPTO won't let you file a patent application in the United States if you didn't receive a foreign filing license. I'm not an Indian patent attorney, but I'm aware that there's something similar in India, and I think there might actually be some type of it might actually be a criminal misdemeanor or something akin to that as well to file a patent application abroad without receiving a foreign filing license from the Indian Patent Office. But this is a scenario that comes up quite often in today's globalized workplace, and so I thought I'd make a quick video to describe some of the options. And yeah, thank you. If you have any questions, just feel free to shoot me an email. Thanks.